the Chief Justice essentially ruled that the Police Service Commission, because of the physical absence or the non-existence of the chairman of the Public Service Commission, that the Police Service Commission is not properly constituted. I beg to disagree. We argued that the Commission's actions will be justified in law by invoking the de facto doctrine.
Attorney General and Legal Affairs Minister Anil Nandlall speaking on weekly program Issues in the News. Nandlall reasoned that the de facto doctrine could have been fully applicable in this case. The de facto doctrine in law validates on grounds of public policy and prevention of a failure of public justice the acts of an official who functions under the color of law, even though it is later discovered that the legality of that person's appointment or election to office is deficient. Meanwhile, 90 News reached out to attorney representing the APNU+AFC Roysdale Forde, who posited that the question of a quorum was substantial since the Commission could not have been fully constituted without a sitting chairman of the Public Service Commission, as he cites the de facto doctrine theorem.
That this was not a question of a quorum, because this was not an act of the Commission, it was an obligation of the chairman of the Police Service Commission and the individual members of the Police Service Commission. There was no question of vacancy because in the first place the person was never appointed.
While the Attorney General agrees with Chief Justice Roxanne George Wilshire Tuesday's ruling that the appointment of Patrick Findlay as chairman of the Police Service Commission was constitutional and that President Irvin Ali properly consulted with Opposition Leader Aubrey Norton on the appointment of the Police Service Commission and the Integrity Commission, Forde is holding out that the Chief Justice erred in this case scenario.
That the court was wrong, however, to find that what took place between the Leader of the Opposition and the President constituted meaningful consultation, because what simply transpired between the Leader of the Opposition and the President was no more of a farce. And we believe it is a farce because it failed to provide the Leader of the Opposition with the information that was necessary upon which he could have formed an opinion. Certainly you cannot simply write a letter and say that those are good persons or these are good persons of standing, and that be constituted as the requirement for the person to be appointed. Obviously they must have a more nuanced rationale for the important appointment of a chairman of a Police Service Commission in the context of our constitutional framework.
This ruling comes after Opposition Leader Aubrey Norton attempted to have the appointment squashed on the basis that the head of state failed to engage him in the constitutionally required meaningful consultation in accordance with Article 211(1) of Guyana's constitution. Norton had asked the court to quash the appointments and for a declaration to be made that all actions taken by the commissions are null, void, and of no force in legal effect. However, the Chief Justice refused to quash the appointments of the constitutional commissions, noting that the constitutional and statutory regime was followed by the President in appointing the chairman and members. The Chief Justice found that sufficient information on the nominees and reasons for their nomination were provided to Norton. In the circumstances, she held that there was procedural fairness and that the consultation process between President Ali and Norton can be deemed sufficient, ruling that the appointments were constitutional and lawful. This is Antonio, reporting for the HCP 90 News.